of you who have never heard me speak or share, my name is Bonnie Canty. I am a licensed attorney. I'm licensed in 5 states: New York, New Jersey, Connecticut, Georgia, and Florida. I currently live in Florida and I will never go back north where it's cold ever again. So, for those of you who endure the snow, more power to you because I will not dig out a car. I am a certified credit counselor and have been for well over 20 years. I do provide consulting services for NACCC and some other people directly. And I do training for this organization. And I really like the training stuff. This should be fun. It's a lot of material, it covers a wide range of things. And so hopefully the information that you get today will give you some additional in-depth knowledge on how to handle collectors that escalate their accounts beyond the normal 1 or 2 months past due, and give you some tools in your toolbox to be able to help you work with your client. So what is the problem? We all know this. The debt collection industry is designed to incentivize their employees to collect money. They employ tactics to put people into automated dialers so that the phone calls where they start out as once or twice in a month start escalating to weekly, to daily, to multiple times a day. The first letters that your clients get are typically, hey, you missed a payment. I'm sure it was an oversight. Give us a call, let us know what's happening. And the next thing that you know, what they're doing is they're sending out letters that say urgent, immediate attention required. And they're basically threatening. And at one time, it used to be they would threaten to put you in jail. But most of you know that that is a violation of the Fair Debt Collection Practices Act. So most creditors try to follow the rules, although we do still have some creditors that employ employees that take those hard lines because they're trying to make their marks in their commissions. And when they get caught doing it, it can mean money in the pocket for the client. But it all starts, as we know as counselors, with asking the right questions and exploring what kind of debts the client has, how they got into debt, the root source of their issues, what their current financial circumstances are, where are they working, how much money are they earning, what are their fixed expenses. It all sounds like putting together a budget, and it is. It's really important to understand the full financial picture when you're dealing with somebody in order to be able to help them. And as we get into working on how we can deal with these law offices that are suing the clients, it's going to be really important to have all of those answers. So right now I do work with an entity that will call me and say, listen, we've got this litigation going on. We're not getting anywhere with them. We need you to contact the attorney for us. And I get in touch with the attorney. But before I do, I give them a host of questions. So let's say, for example, I am told that the client's hardship is that they went through a divorce and they're going to have to pay alimony, and the other party ended up in the house and blah, blah, blah. Well, that's not enough information for me. I want to know, is there any equity in the house? Who got responsibility for the debts? How much total outstanding debt? Is the debt solely in the client's name, or are some of the debts in the former spouse's name? Are there joint debts with the former spouse? Did the court order or agreement specify that bankruptcy couldn't be an option? Did it specify that it could not be done via settlement? Are there any restrictions for the client that have to be considered when dealing with options to resolve it. Okay, so timing really depends on availability of funds by the client. If the clients have money, but they're only 5 days past due, well, that's not the best time to try to negotiate something, unless you're just trying to get back on track and maybe get a late fee waived and put them right back onto a payment plan that the creditor expects, or into a hardship program that the creditor may have available for a 6 to 12-month period. But if I'm trying to settle a debt, I want it to be as old as possible without it actually getting to the escalated legal status that we're going to get into some of that as we go through this. As far as medical debt, my feeling about medical debt is that if you pay them $5 a month, they really can't do a whole lot. So if your clients can send them a token payment until you're ready to deal with it, at least it will usually keep it out of litigation. And that's how I deal with medical debt. It is one of my least priority in terms of debts that I deal with. They're more and more sticking them with debt collectors that do nothing but medical debt, because hospitals and doctors are really not geared to have collection agents working within them. So once a debt is like 30 or 60 days past due and they've sent you a couple of bills, they send it to those medical debt agencies that start acting like collectors. And they're going to make it sound like if you don't pay more that there's a problem, but quite honestly, that's just because they want to get paid. You know, as long as something's being paid, then your clients are not, in most cases, going to be sued. I've never seen anybody sued on medical debt unless it's like well over $100,000. Okay, so we need to know whether or not the debt is secured or unsecured. And, you know, sometimes we need to remember that we're dealing with people that have not been trained in school to understand financial terms. So if you ask them if their debt is secured, they're going to say no, because they may not even know what the word means. So, you know, explain it to them. You know, your mortgage is secured by your house, your car payment is secured by your car. Do you have any loans that are secured with your furniture, with jewelry, so that they understand what you're asking? Is there any third party or a co-signer on the debt? What is that co-signer's relationship to the person you're trying to help? What is the person who co-signs credit like? Are they in good standing, or is it the 95-year-old mother who never needs a car again, owns her home outright, and is not going to pay the credit card bills? Because that's very different than your sister who's 35 years old trying to buy her first house, just got married and has a baby on the way. So, you know, you have to kind of know who the players are when you're dealing with this. So let's take a look, kind of an example to keep in the back of our minds as we're going through this. We've got Carla, and she owns a house with her husband, and she lives in a state where there's no homestead exemption. For those of you who don't know what that is, because you don't have them in your state, in states where there's a homestead exemption, if they try to collect debt against you, they cannot lien your house. They cannot force the sale. They cannot lien your house. And this goes from states like Florida, where if it's your primary home, unless you're a contractor or a mortgage company, you cannot lien a home, to a state like New Jersey or New York, where they can put a lien on the home and can even go so far as to force the sale of the home if there is equity. So everything runs the gamut from state to state in between. The house that they own is worth $500,000 and she owes $350,000. So we know she's got $150,000 worth of equity. She has a car worth 10 grand, but a loan of 17. So she's upside down on the car. So there's really not a lot of risk with the car because it's not worth anything. But the sister co-signed for the car. She has 5 credit cards. So she owes a little around $20,000. The first 4 of the credit cards are just in her name, but the last one, her daughter's on with her. She also has an unsecured personal loan that her husband co-signed. She broke her arm and was out of work for a month. She missed payments with all of her creditors last month, so nobody got paid. And this month, she can only pay some of them. And we need to help her figure out how to handle all of this obligation and to kind of put them in order in terms of priority and make some hard decisions about how to get her back on track and ultimately out of debt. So what do? We go into our toolbox and we look at what's available for Carla. I mean, she can do a consumer workout by contacting the creditors directly. She can consolidate the debt with a loan. She can go into credit counseling. She can do debt settlement, or she could just, do some budget counseling and sit and work with somebody on how to stretch her money. And most of you know all this, so it's kind of a review. But for the consumer workouts, and I don't know if any of you have done this, but if you're working with a client and you're not actually doing debt management, you're not with a debt management company, you may want to have them just contact the creditor and go into a hardship. So she's only a month behind. If she's only a month behind and she's struggling and she can get into the hardship program direct with the creditor, it's not going to show consumer credit counseling on the credit report. It's not going to close the credit card. It's going to give her the ability to get back on track by paying a lower monthly at a lower interest rate and get rid of those late and over limit fees that, may start to accumulate once that first payment is missed. Creditors are not going to discuss this unless you ask. They do not offer it. So it's kind of like even in the student loan realm, if you call up a federal student loan servicer and you're telling them that you're struggling to pay, they're not going to say, well, have you ever considered, pay as you go? Have you ever considered, an income-based repayment plan? They're not going to offer those things. You have to say, well, isn't there other options available to me for paying this debt? So you tell your clients to ask them if they have a hardship program and what is required in order to get into the hardship program. And then they have to go over their hardship. If you're current, you cannot qualify for a hardship program. They will not discuss it with you. These are things that are only available to somebody who is past due, because you're not in a hardship if you're paying your bills. That is the way the creditor views it. If you're 1 month past due, the qualifications to get in are going to be set at a higher bar than if you're 3 months past due, because at 3 months past due, clearly for the last 3 months, you've not in a position to be able to make your payments with them. So something's going on. If you're just 30 days past due, well, maybe, it's an anomaly. So, and they want to collect their fees if they can. So you need to go through the hardship, and a lot of them do it by a budget formula that they have. So it's not in this PowerPoint, but one of the things that I'm going to recommend to all of you, if you've never done it, is to go online to the IRS and look for the IRS set amounts for families, for food, for shelter, for clothing. And they even have where you can find it by county and state. So if you drill it down, and let's say, because I wouldn't know the first thing about what the housing costs are in Ohio, I really wouldn't at this point. I know what they're doing in Florida, and that's about what I know because this is where I live. So in order for me to have an idea what housing costs would look like for a 3-bedroom house, or for a family of 5, I would go and look under the state of Ohio, whatever county in Ohio I'm looking for, and look for the average family's cost of housing, because that is what these creditors are going to be looking for in terms of, are you giving them numbers that are ridiculous? So if I tell you that my housing cost is $3,000 a month and the average person pays $1,200 a month, they're not going to think that that's a hardship. They're going to think that that's ridiculous. So unless I can show that the reason it's so high is because, you know, I had $100,000 in medical bills, I had cancer, I was out of work, I had to pull all the equity out of my house, and now I've got a first mortgage, a second mortgage, and a third mortgage, and that's why it's $3,000 a month and escalated. And if I don't pay it, I'm going to be homeless. You know, you have to, you know, drill down and ask. And it's a good way to kind of gauge whether or not the person you're talking to is completely off the mark with their bills. And you've learned that in a lot of these counseling sessions and looking at the average for housing and where does your client fall? Are they within the normal realm or are they somewhere outside of it? But if you call the creditors, sometimes a lender, if it's a car payment, if it's a mortgage, they'll move the payments to the end of the loan. So now you're not reporting on your credit report delinquent. And now the client doesn't have to feel like they're past due and there's no late fees. And if it's a credit card and they can get into a hardship program, that might be a 6-month or a 12-month program, but it'll get them back on track. Then there's the loan. Well, in order to get a loan, you have to have good credit. So if their credit was okay up until recently when they just started missing payments, maybe they still qualify. But most of the clients that I've experienced in this industry are too far gone to qualify for more loans unless it's a payday loan. And with the interest rates that those charge and as quickly as they need to be repaid, they don't make sense for people. But one of the things is, do they have a house? Is there equity? Does it make sense for them to take a second mortgage? I don't like it. I never advocate for people to tie up their home and their potential future with unsecured debt being paid for using that equity, but it's an option. Going to a credit card, if they're still getting credit card offers, if they haven't been cut off, sometimes the credit cards give really good terms for, you know, initial transfers if you're opening a new card, and waive some of those fees where it's like 0% as long as you pay it within 6 months or 12 months. It can give them the ability to consolidate some of the debt that's past due and move it around. Again, it's risky. You got to know the person. If they move the debt and now they get out of debt with the other credit card, well, they still have that credit line open and now they could, you know, be in twice as much debt at the end of the day than they started out with. So if they have a shopping problem, it's not recommended. If they have a gambling problem, it's not recommended. You know, we have to get into the underlying cause for the debt in order to see if that's even a viable solution that we would want to recommend. There's pros and there's cons to the loans, and we're all somewhat familiar with them. So you can take a look at the screen. We just talked about the credit card. We could do credit counseling. So a credit counseling repayment plan is one where an entity that is and it's got to be a 501c3. It's got to be an entity recognized by the creditors. It's got to be ISO certified. It's got to be approved by the state and licensed. It's got to be bonded. So it's got to be a legitimate entity. Because if it's not a legitimate entity, they're not going to get the client the best possible benefits that are out there. But assuming they get with a legitimate credit counseling entity, they will be able to put a client who is anywhere from 30 days to charge-off status into a credit counseling repayment plan that should reduce their minimum monthlies, reduce the overall interest they're paying, stop any and all fees that are being assessed, and get their accounts re-aged after they've made 3 to 4 consecutive payments. So the benefits to the people, I don't know why this stuff pops up. Cancel. The benefits to the people are that if they were paying let's say $2,000 a month for their credit cards, and going into a credit counseling plan will get their monthly payments down to $1,200 a month and get their interest rates that are now at 30 because they're delinquent 2 months down to an average of 12. It used to be 0 at one time, but they don't do that anymore. If they get them down to 12%, and if they don't have to pay late fees and over limit fees because they get suppressed as long as they're making the plan payments, the person's going to be in a much better position to be able to repay their debt and stay on track. The cards do get closed for those of you who are not familiar, and they will report closed by the credit grantor, and the credit reports will reflect that the credit card is being repaid through a credit counseling program. But that is only during the repayment period. Once the repayment is done, it just shows that it was paid as agreed for the last typically about 4 to 5 years to do a debt management plan. So it helps somebody to get their payments back on track, even though it's a closed debt, and get it paid off as paid as agreed month after month after month over the course of the repayment plan. So it's not a bad option if the person can afford the monthly payments in order to deal with the credit cards. But again, there's a window. If they're not at least 30 days past due, it doesn't help them, and they're not going to get the benefits. If they're past charge-off status with the creditor, they're not going to re-age the accounts, and they're not going to get the benefits. So there's only a small window of opportunity of about 1 to 4 months where the people are really good candidates for credit counseling. Then there's debt settlement. Settlement is where you're paying less than the full amount owed on the debt. Nothing gets brought current. The debts get worse and worse. The client's credit deteriorates as they're going through this process. So unless you have a client that says, listen, I hit the lottery and I got 10 grand, but I owe 30. What can you do to help me get rid of as much of this debt as possible if I give you the whole 10 grand to get rid of it? That's a scenario where the client is coming to you with money in hand, and however bad it is now, you might be able to cut the bleeding off at the knees. But most people come and say, hey, I can't afford a full payment. I don't want to pay back all of what I owe, but I want to do something more than nothing. And how much can you get it settled for? And I have to save money month after month after month because I have no money to work with. So it makes it much more difficult. But debt settlement can be done in stages. You can negotiate a 60% settlement on a balance and pay it out over a period of time. Again, that depends on the creditor. It depends if you're dealing with the original creditor, whether you're dealing with a collection agency, whether you're dealing with an attorney's office. It depends on who that creditor is. Some creditors are notoriously impossible, and other creditors, it's like, pulling fish out of a barrel. It's easy. All you do is ask, and they work with you. But you can't, see if it's an option if you don't try. And over time, you make your connections as a counselor if you add this to your arsenal of tools in your toolbox, because you'll start to make friends with some of the creditors and some of the people, and you'll have direct lines and hooks into them to be able to know who to call. So you're negotiating less than the full balance, and you're bringing that back to the client, and you're seeing if they can do it. Now, there's settlement companies out there. They typically charge a lot of money for their services, a lot more than maybe you would do as a private counselor. I don't know what your fee structures are, but typically there are several ways of doing this. One is you don't charge for the settlements at all. You just charge them consulting for providing financial counseling and education. which is a lot safer for an independent who may dabble a little bit with debt settlement, because a lot of debt settlement falls under the credit counseling statutes and requires licensing, bonding, fee limitations, etc. Most states do not allow debt settlement companies to charge upfront fees. They have to wait until a debt is fully settled to be able to collect a fee, and then they can collect a portion of the savings to the client, and that has to be fully disclosed in an agreement. If, however, we are merely acting with the client on the phone, making phone calls with the client to help them negotiate with the creditor, we're coaching them to get on the phone and negotiate themselves, and we're charging them fees for our services as an educator and a coach, then you're not actually providing debt settlement. I would warn you against collecting the money, because that is going to get you into a lot of trouble if you're holding the person's money and paying it out. Let them hold their own money. If you do make a deal for them to make a monthly payment plan on a debt settlement, make sure any agreements are signed by the client and that you're not the one signing anything. And make sure the clients are paying them directly. Put that onus on them. So that's, debt settlement. Now, let's talk a little bit about the creditors, because when you're talking about advanced collections, you need to know what the creditors can and what they cannot do. So they can keep the debts in-house. If they keep the debt in-house, then they're the ones that are calling, and they are not subject to the Fair Debt Collection Practices Act, at least not the federal one, because that is built to address acts and behaviors of third-party creditors. So if I'm Discover and you owe me money, and my agent who's in my collection department at Discover calls you, they are not bound by the same rules as when I place it with ABC Collection Association, and ABC Collection is calling the client because they are a third party collecting for somebody else. That's true even if they sell the debt. So if Discover sells the debt to LVNV Funding, and LVNV now owns the debt, it doesn't put them in the shoes of the original creditor. It still qualifies them as a third party for the purposes of being subject to the Federal Fair Debt Collection Practices Act. So they cannot call before a certain time of the day. They cannot harass people. They cannot call people after they've been advised that they cannot accept calls at work. They can't call work anymore. They cannot contact third parties and discuss your debt with them. So there are a lot of protections under the Act for people that are done at a federal level. At the state level, most states have their own state act, which some do and some do not include the original creditor. And some of them are more expansive than the federal act. And it's good to just be familiar with them, because it helps you be able to educate your clients on what they're not allowed, on what a collector is not allowed to do. I don't get into suing creditors for violations of the act, but there are attorneys that specialize in that type of law. And if clients are really being harassed, or they have creditors that are really exceeding the line, it's good to maybe know who those attorneys might be in your general location where you provide assistance to people, so that you could potentially refer the client to the attorney. In those types of cases, the clients do not pay the attorney a fee. The attorneys, if they feel that there is a genuine violation of the acts, will act on their own behalf, on their own dime, just like a personal injury attorney, because they're going to end up getting paid by the creditor, and they will get their full fees. The client is going to be limited based upon the statute. On the federal side, it's $1,000 for a violation. On the state side, it may or may not be expanded beyond that, but those attorneys are not limited. So if they spend hours and hours and hours of time and run up a bill of $7,000 and they can prove a violation, that attorney gets their $7,000 from the creditor. The client gets $1,000. And if the client owes a debt to the creditor, sometimes they can negotiate the debt to go away along with resolving the case. So it's something to think about in terms of, a tool in your box to have in your arsenal, and to maybe reach out and make some connections with attorneys that do that work. They can damage your client's credit report. They're going to report to the credit bureau, whether they do it every 30 days or every 60 days. They do go ahead and report to the bureau that the client is behind 30 days, 60 days, 90 days charge off. They can revoke credit privileges, just say, okay, I'm closing the account, and they can sue. So the creditors have a host of things that they can do in order to make somebody's life difficult. Not only do they have these remedies, but there's other remedies depending upon who the creditor is. If it's a mortgage, they can foreclose on the house. If it's a car, they could repossess the vehicle. If it's a utility bill, they could shut off the water or the lights. If it's a collection agency or an attorney, they're going to drive people crazy until they get payment. They're going to park on the credit report and escalate it to litigation. There's the lawsuits and judgments. There's levies against bank accounts. There's wage garnishments, and there's attachment of personal property. So the creditors have an arsenal at their disposal to try to collect, and depending upon the state that the person lives in will depend upon how far that they can go. So we're just going to talk a little bit about each of these things. I'm not going to get in depth into them. There are other CEUs that explore a lot of these things more in depth if you're interested in them. So foreclosure is the legal process that a lender uses to recover the amount owed on a defaulted loan by taking ownership of and selling the mortgaged property. There are two types of foreclosure. So either you're in a state where they have to go to court and file a lawsuit. That's what we have here in Florida. Or you're in a state where all they have to do is give you notice that you're in default, a certain amount of time to cure it. And if you don't cure it, they can just put your house up for sale through the proper notice procedures and go straight into foreclosure. So one is a notice state and one is a non-notice, one is a judicial state and one is a non-judicial state. So it's important to know whether you're in a judicial or non-judicial state, because a non-judicial state, the foreclosure process is much quicker, and the client doesn't have the ability to put in an answer to slow the process down. In a state where it goes into court, as long as your client answers a petition or a complaint and puts in an answer, it will slow down the legal process. And we're going to talk about that a little bit more in depth in a minute. Okay, so here's the foreclosure of the process of foreclosure in the judicial state, the process of the foreclosure in the non-judicial state, just so that you have something that you can look at and refer to if you needed to explain this to somebody. Repossession. You ever hear the repo guys out there in the parking lot, whose car is he here to get? And who's going to come out and find their car's not there anymore at the end of the workday. So they don't need to go to court usually to get the order. Most car companies that do lending have repossession clauses in their contracts, where if a certain number of payments are missed, they are just going to send somebody out. They're going to hook up the car. They're going to take it away. And then if you want the car back, you got to pay all of the repo fees, all of the past due amounts, and usually some additional fees in order to try to get the car back. So repossession is very real. It happens every day. There really are repo people out there. I know they had that show on TV for a while, where they would go and they would show you people trying to pick up people's cars and what they would go through with the people trying to stop them. So if somebody's past due, they need to call their lender. It's some of our job as counselors is to help people get past their fears. And it seems scary to talk to us about their financial problems, nonetheless, to call up the people that they owe the money to. And what we need to remind them is they're just speaking to somebody like you and I, like themselves. The person on the other end of the phone isn't the one owed the money. They're doing a job and they're getting paid to sit there and help whoever they're working for collect money owed to them. And if they think about it as just talking to another person rather than talking to a big, huge entity that can come down and, rip their car out from under them, it becomes a little bit easier. Sometimes role playing with them, if you're going to have them make the phone calls, can help them get more comfortable with what they should be saying when they're talking to people. But when it comes to a car, if you've never moved any payments to the end of the loan, if somebody is getting 2 months past due, they really should pick up the phone and see if that is an available option rather than losing the vehicle altogether. Utilities shut off, you come home, the water's not on. You come home and the lights don't work. A lot of times when that happens, the party who has the shut off has to now come out of pocket an additional security deposit plus pay the outstanding bill to get it turned back on. So if somebody's running behind on their utilities and they need those services, they are way better off finding out if either their community might have some programs for people who need help. There's disability help available. There's unemployed people's help available. And especially since we've had a lot of people out of work because of the COVID problem we've had, there are programs that are out there to help people with rent, to help people with their utilities. And as counselors, it's on us to become familiar with what those programs are so that we can steer our clients to those programs. Doesn't mean we need to do the programs for them. If we want to help them fill out an application because they're confused or it requires part of it to be a budget, fine. But sometimes people just need the information as to where to go for help and where their source of information. Most collection agencies get 50 to 60% of the funds that they recover. So the higher amount that they're able to get, the better for them. So when you're negotiating with them, particularly from a debt settlement standpoint, we need to keep in mind that they are not going to give us their best possible deal. We're going to have to work for the best possible deal. And sometimes it may sound a little like begging, but it's just like anything else. We got to work on them. Well, if we can't get it down to this, my client isn't going to be able to do it. And if my client can't get all these debts resolved at 30% across the board, then they might as well just file bankruptcy because this is going to be impossible. So let me talk to the client. I know you're at 70%. Let me see what I can do. I'll be back in touch with you in a week or two. And you let them sit and sweat it out. A lot of these collection agencies only get the debts placed with them for a period of time. Sometimes it's a 90-day contract, sometimes it's a 6-month contract, but most of them do not get the debts on an indefinite basis. So if you're getting closer to the time that the collection agency is probably going to have the account pulled out from under them, them resolving it at a lower amount if they have the flexibility to do it, which they do if they bought the debt and they own it, which they may or may not have if they're operating under guidelines given by an original creditor. Guidelines by an original creditor make it way more difficult to get past stage one, but it's not impossible. So what you have to keep in mind is just because the person on the other end of the phone tells you that the only thing Bank of America is going to do is accept 80% of the outstanding balance paid at the most over a period of 12 months, that is not necessarily true. That is all that particular individual is authorized to do. Asked to speak to a supervisor. The supervisor usually has a little bit more room than the first agent. If the supervisor can't do it, try to speak to a manager and ask the manager to submit it to their client. Because at the end of the day, if it goes in a package deal to their client with the hardship, humanizing the client to them as to what the underlying problem is. Let's say your client comes to you and they have cancer and they are stage 4 and they don't know whether or not this round of chemo is going to cure them or kill them. This person may never get paid. So in that kind of a circumstance, I'm going to tell them my client isn't working, they're on disability, there is no income, there is no way to collect against wages, they are deathly ill, they could die during this round of chemo. Wouldn't you like to see some money go into your client's pocket than to rely on whether or not there's going to be money available in a state if they die? So, it literally needs to be taken there. And I take it there every time. I will go to the worst possible case picture I could paint for them to try to get what I want to get, because it's about trying to do and advocate for your clients. Each of these collectors, whether they're an agency or whether it's the original, they go through different stages. The first 30 days of delinquency is really not a big deal. 30 to 119 days is, a whole different protocol that the collectors are given as to what they're supposed to be doing. And then once it hits 120 days and it's in a charge-off status, that's yet a different protocol. And each collector has its own set of protocol that they go by. But it takes time to develop a knowledge as to what you're looking at. Like, does Bank of America or MBNA or Discover charge off at 120 days, or do they charge off at 180 days? Do they charge off at 160? If they're in the first 30 days of delinquency, will they give you a settlement, or do you need to wait until at least 90 plus days? So as you're starting on this journey, and as you're talking to one another, you need to find out what each other has been able to do and start building kind of a data bank where you can go pull it up and see, here's the best number to get to a collector, here's the best number to get to a supervisor, here was a really friendly agent, here's a recovery person, this is what I've been able to get on the lowest, this is what the worst case scenario has been, this is how long they'll take a payout over. And you need to keep notes, because all of that helps you go back 6 months later when you have to deal with the same creditor again and have an idea as a starting place what you might be looking at, so that you're not, being unrealistic with what's going to happen as you're talking to the creditor. Everybody, we talked a lot about the FDCPA, and they can't mislead people, they can't interrupt work, they can't threaten people, they can't deposit a check before the date on the check. I hear that a lot. I gave them a post-dated check and then they deposited it. Well, people should not give post-dated checks. Never, 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 never. They don't know if the check is going to be good. A lot of states have statutes where it's a crime to write a bad check. So if you write the check and there's no money in the account and you knew there was not money, but you thought there would be money, you might actually subject yourself to criminal charges or triple damages or. So people should never do that. Never, 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 never. Really bad practice. Okay, time's up. Here we go. We're about to get sued. They're done. They tried everything. They didn't collect. They're looking at what am I going to do? How do I force this client's hand? How do I get my money? How do we get paid? So they're going to look at a bunch of things. And it's not that an individual is going to sit there and look at this. There are algorithms that are built into all of these creditors' platforms that consider the statute of limitations to sue for a debt in the state that either A, the credit card agreement designates is going to be used with the consumer, or B, the state where the person lives, if there is no such designation of venue in the contract. And I know it seems funny because we get these credit cards and it's not like we sign a contract, but there are terms and conditions that come with them. And there are venue clauses in them. And the venue clauses that are in them control whose state law applies. So even if you live in Florida and they sue you in Florida, it doesn't mean that Florida law applies. It may mean that a law of a state that has a longer statute of limitation applies because the creditor was smart enough to get themselves incorporated in that state, put a venue clause in their credit card agreement, and elongate the statute of limitations by designating a state with a longer statute. Statute of limitations could be anywhere from 2 years to 6 years. If you actually take the advanced creditor course, I have tables with all of this stuff in them that shows you state by state the statute of limitations. It also shows you whether or not there's garnishment laws and things of that nature. They look at how much outstanding debt they are showing. You got to remember, when you look at a credit report and you see at the back of it all of those soft inquiries, and a lot of the soft inquiries are creditors that the person has had and has debts with. The reason they're doing that is because they're looking to see what the person's credit profile is now. And again, it's not a human doing it, it's a computer program that's uploading the most recent credit information, grabbing the credit score, grabbing the overall outstanding debt, seeing whether or not there's other debts that are past due. And when you're considering as a creditor whether or not to sue, the person who gets to the courthouse steps first and gets that first judgment wins. And when I say that, it's because they are actually first in line for garnishment, first in line to attach the bank account. So whoever gets that first judgment gets first dibs at collecting their money. So as judgments line up, they wait in line to get paid. So creditors will consider how close other debts are to being maxed out, being delinquent, and the likelihood that they may sue so that they can be first in line. The amount owed plays a role. Whether or not it shows that the person's employed plays a role. So all of these things are factors that the algorithm considers. The statute of limitations is how long they can sue for. And it usually runs from the date of the last payment or purchase. So when a client says, well, I'm just going to make a payment and they haven't paid something in the last 3.5 years and the statute is about to run, I don't know that I would want them to pay, because if it passes the statute, there might be a moral obligation to pay, but they can't legally be forced to pay. So let's go back to Carla. She used the tools we gave her. She negotiated with her mortgage lender. She negotiated with her car loan. She moved those payments to the end of the loans and got out of delinquency. So she's current on those debts, which is good. She's, on the mortgage with her husband. Carla entered into the debt management plan for the credit cards, but not the one that her daughter was the co-signer on because she didn't want to affect her daughter's credit. She refinanced the personal loan and included the outstanding balance of the credit card she had with her daughter so that she could get off the personal loan and off the credit card the third party that was the co-signers. But she lost her overtime and couldn't keep up with the DMP program, and all of the credit cards that had been in the program are now charged off and she's being sued. So now we have to look at going a whole different direction because Carla can't maintain what she thought she could afford to maintain. So now she's being sued. Well, what happens when she's sued? When she's sued, she gets a summons. The summons is either hand delivered, mailed, depends on what the state statute requires. Along with the summons is a complaint. The complaint sets out what it is the person is being sued for, what theory they're being sued under, and the amount of money that the creditor is looking to collect. Then there could be motions prior to filing an answer after the motions fail, if they fail, discovery, which is exchange of information back and forth to prepare for trial, more motions, mediation, which is a meeting to see if you can get an agreement, trial, and then enforcement of the judgment. So we're going to look a little bit at this process, not because I expect you all to walk away from this as attorneys, but because if you're guiding somebody to understand the process, helps you to be a better counselor because you're able to help them understand the process. Because the creditors like to pretend that it does. And that's the best way that I can say that, because honestly, the creditor's biggest tool is to park things on a credit report. And as long as it's sitting on a credit report, if somebody tries to buy a house ever, they're going to be asked by the mortgage entity to clear up old debts. Even if they're really old, they don't want to see them on there and open and charged off. They want to see that these things have been resolved in order to make a mortgage. So if, let's say I'm ABC Credit and I've had the debt for a year and I now sell it to LVNV Funding, and LVNV Funding reports the debt as of the date that they buy it. Well, now the 2 prior years of that collection agency and the year before that the original creditor had it would already have them 3 years into a statute and 3 years into the ability to leave it on the credit report. So now you've got 2 time frames that are working back to back. You've got the statute of limitations, which says how long they have to go into court, and you've got the time frame that they can leave that debt on the credit report. So if the statute of limitations is 4 years and 3 years have already passed, that creditor only has a year unless the client goes and makes a purchase or the client makes a payment, because that would again restart it because it's an actual activity. The sale of the debt from one creditor to the other, or the placement of a debt from one collection agent to another, is not an activity for the purposes of the statute of limitations. So they can do that as often as they want, but if the statute of limitations could be extended, if they did that, everybody would do that. Every creditor would wait until the month before the statute's going to run and transfer it to some other agency that they opened up under their brother's name instead of theirs, and they would keep these debts out there forever, never expiring under the statute. So no, the date of last activity, the date of last payment, whatever that is, you then have the 3 years, the 2 years, the 4 years from that date to sue. It doesn't mean that a creditor doesn't sue past the statute. So when I said the first thing after being served might be a motion, one of the motions that I tell people to file is a motion to dismiss for the statute of limitations being expired. Because if they're already outside of the time frame and they can't prove that they're inside the time frame, the courts will dismiss it and it will go away. And that's a very winnable motion. And there are samples out there. People could do it on their own, or they can do it through an attorney. But if it's past the statute, you absolutely want to tell them to make a motion to dismiss, because once they get it dismissed, there's no legal requirement to pay it. There's just the moral obligation if they choose to pay it. On the credit report is a little bit different, because on the credit report, you're not dealing with the court system, you're dealing with the credit bureaus. So on the credit report, you can have a bad debt on there for 7 years from the date of last activity. So a lot of the creditors like to leave it on there as long as possible, especially the debt buyers that are buying it for pennies on the dollar 6, 7 years after the debt is owed. Because if they can now appear on the credit report and somebody's going to buy a house, maybe they don't have time to sit and fight to get it off the credit report, and they're going to get paid even though they can't sue for it, even though they shouldn't be on the credit report. So, those are some of the, what I call the low-hanging fruit cases, where if you're going to be trying to clean up somebody's credit report or help them get rid of things that do not belong on there, a debt that hasn't been paid in 10 years, that the last activity was 10 years ago, but it's moved from collection agency to collection agency, and the date of last activity looks like it was 2 years ago, is absolutely something that should be challenged, and that debt should be removed from that report. So there are the 2 time frames to consider. So this is a sample summons. I just picked one from a random set of summonses. And in order for you to, kind of help your clients, it's all about reading. If you, can read, they can read. You just need to read and understand the terminology to make sense out of it. So they're being told that they're being summoned to answer a complaint in the action. They may be worded a little bit different from state to state, but they're all pretty similar. And to serve a copy of your answer, or if the complaint doesn't come with the summons, to serve a notice that you're appearing to the attorney who filed the lawsuit within 20 days after you get the summons. Don't count the day that you got the summons, so it's telling you how to count the days. Or within 30 days after the summons is complete, if the summons is not personally delivered to you. So what this particular summons says is, when you get the summons, you need to say, hey, I'm here, I got this. If you got a complaint, you need to answer it or file a motion or do something. And you need to do it within 20 days, starting with the day after you receive it. You're going to count on a calendar 20 days, and that's how much time you have to put in some kind of a response. That is if you're personally handed the papers from a processor. If you get it in the mail, you have 30 days. That's what this is telling you, because you weren't personally delivered it, then you get 30 days. If you don't answer, appear, file anything, do anything to let the court know that you care, they can, by what's called default, meaning they got notice, they did nothing, I want my judgment, and then the court says, okay, you can have your judgment. So if we don't want the court to just say, okay, they did nothing, so creditor wins, then you have to do something. This is what every summons does. It tells you what you need to do. It tells you how many days you need to do it in. And It will give you typically the court that you need to serve. It'll be in there. It'll tell you the court address that you need to serve. And if you see where it says name of law firm and address, it'll have the name of the lawyer for the creditor that you need to provide a response to. So for your purposes, because you're not lawyers, you're not expected to be lawyers, somebody comes to you, they've been sued, they want to try to negotiate with the creditor and not have a judgment entered against them. The best thing for them to do would be to make a notation on a calendar as to when they have to have a response filed to avoid a default. So if the response needs to be filed by the 15th of this month, and we're at the 14th day and there's nothing been resolved, that person needs to overnight mail to the court and to this attorney something that says, hey, I'm here. I don't agree with what you're saying. It's not right. I don't owe that much. You charge too many fees. You're past the statute. Whatever you want to put in there is your reason to be able to make sure that a default doesn't get entered and you live to see another day. Okay, so you're there and you're able to continue the fight and try to resolve the outstanding debt. So you're not going to necessarily do it for them because you're not practicing law, but you can give them samples or direct them to places online to find samples of how to do an answer. Most courts, when somebody does not have a lawyer, will take even a letter that has in this case in New York, they use index numbers. In a lot of cases, they call them case numbers, that as long as the court that it's in is somehow listed on the piece of paper and the case number is somehow listed on the piece of paper, if it's a letter that says, dear judge, I don't understand why this creditor is suing me. I don't even know who they are. I never borrowed any money from LVNV funding. All these years, I've never received one piece of mail from them. I don't know what this debt is in relation to, and I don't owe this money. The judge is going to take that as an answer and consider it a pleading and force the creditor to go through the process. So it does not have to be some fancy schmancy itemized paragraph by paragraph response like an attorney would be expected to do. Okay, so typically in a complaint for collection of money, you're usually looking at either breach of contract, including those credit card agreements, which are considered contracts in almost every state, account stated, or unjust enrichment. So I'm just going to give you an idea what these things are. Breach of contract is you and I agree that you're going to make at least minimum payments a month under the terms of this credit card agreement. If you default, the interest rate's going to go up. I'm going to be allowed to charge you fees, blah, 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 a whole bunch of stuff in this little tiny writing in this little form that we send to you that you're not going to read, that's going to go in the trash or maybe in your spam box, but we gave it to you, so therefore it exists and therefore you have to abide by it. Okay, so now you have a breach of contract. I didn't make the payments like I agreed to do. So I breached this agreement and you're suing me. That's breach of contract. Account stated. That is when the creditor, and a lot of times this is third-party collectors, do this under account stated because they didn't actually have a contract. So unless they are going to say that they receive the contract under assignment and attach a copy of all of the assignments to get them it, they may do account stated, which is every month you got a bill, first from the original creditor and now from me. And every month you had the opportunity to say, I don't owe that money, and you didn't. You had an opportunity to challenge the bill, you didn't. And so therefore you owe it. And you attach the creditor attaches a bunch of statements to the complaint showing that there's been account stated every month and that there's been no payment. That's account stated. Unjust enrichment's a little bit different. It's not a legal theory, it's an equitable theory. So, under an equitable theory, I lent you money, you got to use that money and buy stuff. I never got paid my money back. Therefore, your life was enriched. You received a benefit. I got no benefit. I only had a detriment. My benefit was that I was going to be paid back with interest. I did not receive my benefit. You cannot be unjustly enriched. It's not fair. So it's kind of a not fair argument. Those are the typical causes of action for somebody who's being sued for a debt. Next, what are the defenses? So, any of these could be used, and it's like kind of giving the clients a list. You're not going to do it for them, but you could say, listen, if you didn't have a contract, you could say there's no contract. They're saying there's a contract, nothing's attached to the complaint. So tell them there was no contract. If they already paid it and they have proof that they paid it, that's an absolute defense to a debt. If it wasn't their account, somebody opened an account in their name and there was identity theft, there's things that need to be done. The theft needs to be reported to the police. They need to get police reports. They need to contact the creditor. They need to speak to their fraud department. They need to give them all the information they have. And they need to be prepared to follow through and prosecute. So if it's your kid, if it's your brother, if it's your sister, your aunt, your uncle, or some other relative, friend, whatever it is, and you know that they did it and it wasn't you and you don't want to put them in jail, then you probably shouldn't use that defense. Sometimes it's simply the wrong person. They have the same name. Jones is a common name. So Carla Jones, there's probably, 10,000 of them in this country. They just happened to find one and thought it was the same Carla that they made the loan to because they lost track of her, and they're suing the wrong person. There's no statements, and it's an account stated claim. There was no promise to repay the debt. It was a gift because it's not a creditor that's a company. Maybe it's a creditor that's a person. Maybe you want to make a motion to change venue. They're suing you in the city of New York, and you now live in Albany, New York, which is a 3.5-hour car ride away from Manhattan, and you don't want to have to go to Manhattan to go to court. So you want to make a motion to change the venue. Maybe you need more time to answer. Sometimes if you're trying to negotiate a settlement, you don't want to put in an answer. You just want to file a piece of paper that says, hi, I'm trying to work something out with the creditor and I need more time to hire an attorney or put in an answer and figure out how to deal with this lawsuit. So that's enough to be considered by a judge a motion for extension of time. The creditor would have to either get an agreed order giving you a time frame, or would have to set it for a hearing in front of a judge for the judge to say, hey, you have until next Wednesday to put in an answer, or I'm giving them their default. A motion to dismiss, we talked about it being past the statute of limitations. Maybe they weren't served according to the statute. Maybe they're not stating an actual claim in their complaint. Maybe they don't have jurisdiction over the person. So there are defenses. Now, once you start getting into those kinds of motions and defenses, you're probably beyond the scope of somebody representing themselves. But just to give you an idea and educate you a little bit so that if you were to know that they're out there and somebody were to tell you that something strange is going on, you might be able to say to them, well, you might want to hire a lawyer to file a motion because that's beyond what I can do. These are the different things that go into an answer if you're actually doing it formally. And you're going to get this PowerPoint as part of being here. So I'm not going to sit and read each one. So if there was a complaint, and this is the best way to describe it, the way attorneys do it is that there's a complaint, and the first thing says the plaintiff issued defendant a credit card on January 1st, 2019. So in the answer, I'm going to put number 1, and I'm just going to say admits, because they gave me a credit card on January 1st, 2019. So I'm going to admit that. If I didn't get a credit card from them, and I don't know who they are, because now it's some other person who allegedly bought this debt, and I never heard of them, I'm going to deny it. Defendant made purchases, deny. Defendant was issued statements, deny. And you know what? The more stuff you deny, the more stuff the plaintiff has to prove. They have to prove the allegations in their complaint. If you admit all of the allegations, there's nothing for them to prove. There is no controversy, they win. So there has to be some amount of denials. So either the person's just going to write a letter and send it in, or if the person wants to try to answer each item that's listed in a complaint, they have to deny some of what's there, even if it's just to deny the amount. And a lot of times that's what I'll tell people. Listen, if you're not sure that they did the math correctly when they calculated your interest, you can deny the amount, and you can legitimately do that because you don't understand how they arrived at that number. Now, again, getting beyond the basics, there are affirmative defenses. Let's say the person got a credit card issued to them and they were only 16 years old. Well, guess what? A minor cannot enter into a contract. So that is not enforceable against that person. And that would be a defense. Yes, I got the credit card. Yes, I used the credit card. Yes, I incurred the debt. However, at the time that I was issued the credit card, and even today, as we were about to go to court, I was a minor and I was not in a position to enter into a contract, and therefore they cannot enforce this contract against me, and I don't owe the money. So depending upon what it is, this is just a list of things that if a client were to say to you, you know, I was mentally ill and had just come out of, you know, a hospital where I spent, you know, 3 months from a nervous breakdown when my husband left me and ran off with his secretary and whatever the case may be. So if you hear anything that might be one of these possible things, that's the time that they should potentially talk to an attorney about filing a response with a defense that might get them out from being responsible for the debt. Counterclaims. Counterclaim is when I have a claim against you. So in the case where they're being sued for a debt, but the creditor is a collection agency and they have violated the federal and state FDCPA collection rules, they may want an attorney that specializes in that to respond to the complaint and assert a counterclaim for violating those acts while trying to collect the debt, in which event, if they're successful on their counterclaim, it may offset or completely cancel out the debt and put money in the debtor's pocket. So that again would require an attorney, and it's just to give you an idea as to what some of those acts are that are out there that may lend themselves to counterclaims on the part of a debtor who might have been not provided correct billing statements, that, you know, might have had a settlement agreement that got breached. There might be some malpractice if there was medical. Then there's the exchange of documents. That's what discovery is all about. It could be done through a bunch of different manners. It could be written questions. Those are called interrogatories. It's just a bunch of questions in writing. It could be a notice to produce, which is a list of documents that you want or they want. Admissions, which says, admit that you were issued a credit card on January 1st, 2019, admit that on March 25th, you went out and bought a living room set at Rooms to Go and charged it to your credit card. So admissions are a list of things where they're asking you to admit things. And then deposition is where you actually sit in the room with the other side and they ask you questions in front of a court reporter and record the information. After discovery, there's other motions, maybe motions to dismiss, summary judgment, a whole host of things that you're not expected to know. And then the trial, maybe mediation. Sometimes judges make people go to mediation. Now, this whole process has assumed we're in a civil court, not a small claims civil court, because when you're dealing with a small claims scenario in almost every jurisdiction, the complaint is going to give the person who gets served with it a date to show up in court. They don't have to necessarily put in a written answer. They just need to appear in the courthouse at the designated time and place so that the judge knows that they're there. And typically they will send the people to a room with a mediator right there in the courthouse to see if they can get them to reach an agreement to settle it because it's small claims. And then, and only then, if they're unable to settle the small claims, they tell the judge that they need a trial date, and then the judge gives a very short time turnaround trial date, because small claims is designed to move cases more quickly and to have things done within a very, very short time frame, usually a couple of months. Regular litigation can extend for 2 years, 3 years. It depends on how bogged down a particular court system is. Once they get the judgment, one of the best ways for a creditor to try to enforce it is through wage garnishment. And wage garnishment is when the statute says that when you have a judgment, you can take up to 25% of the person's disposable income each time they get paid in order to satisfy the amount of money that they owe to you. Now, state statutes dictate whether or not wage garnishment is, one, available within the state, two, what percentage of the disposable income is garnishable, and whether or not there are any exemptions to garnishment within the state. So by way of example, there are states that say if you're the head of household and you're supporting people, your wages cannot be garnished. There are statutes that say if you make 2 times the poverty level, your wages cannot be garnished. So you'd have to look to see if your client falls within some exemption. And those are good things to know when you're trying to negotiate a settlement. Because if you know that your client makes minimum wage and that minimum wage is going to be considered below the poverty level in your state, and that their wages are not going to be garnishable if the creditor gets a judgment against them, you could tell the creditor, listen, even if you get a judgment against them, my client makes below poverty level, you're not going to be able to collect through wage garnishment. They don't own anything. They don't have any bank accounts. They don't have any money. So, if we can reach an agreement here and they truly want to pay you, you're going to be a lot better off, because if they don't voluntarily pay you, even if you get a judgment, you're not going to be able to collect. They can attach personal property. We talked about this, whether it's the TV, collectibles, artwork, jewelry. And again, this all depends on the state. Some states are not going to allow this, and other states are going to let the sheriff advertise that everything in your house is going to be auctioned on Saturday. I had a client once. They were in New Jersey, and it was a young guy. He lived with his parents, and he owed some money. They got a judgment against him, and he called up. He was having a panic attack. The sheriff was going around the neighborhood, and he was posting on like telephone poles, and on the billboards and any place that you could post that there was going to be an auction of everything that belonged, everything that was inside the premises of a address where this guy lived. And he lived at his parents' house. So none of the stuff was his. He literally owned nothing, had nothing. And the sheriff is posting all over the neighborhood to his parents' utter disgust, embarrassment, and everything. And they were like totally losing it that they were going to sell everything that his parents owned that weekend. I had to get on the phone with the sheriff where this guy was from and explain to the sheriff that this kid didn't own anything. The kid was living with his parents, that his parents, it was all his parents' stuff, and I had to get him to go retract all this. But it was a nightmare. And, you know, depending upon where people live, depends upon how far they can go to collect. So we're going to avoid this whole process and all of this needing to feel like you have an idea what to do as an attorney by negotiating. We're going to figure out the client's hardship. We're going to get to the underlying causes. We're going to do a budget. We're going to explore every potential source of funds. If the client has family they can borrow from, if the client has credit cards they can use to solve the problem, if the client can get a part-time job for a couple of months, whatever it is, we're going to go into our toolbox and we're going to try to figure out, now that they've been sued, how do we fix this so that they don't go and sell their stuff, they don't repo things, they don't get judgments against them. And a judgment no longer, just so that you know, I was going to do this as a question, but we're getting close to the end. A judgment no longer factors into a credit score. So if a judgment is actually entered against somebody as part of the negotiating process, which is very, very usual, once somebody's been sued, creditors don't like to dismiss lawsuits unless it's a lump sum settlement. If there's some kind of payout over time, they like to get their judgment with the ability to go and have the judgment executed on if there's a default on the settlement payment plan, so that this way they don't have to go re-incur fees, reserve the person, etc. Judgments used to factor into a credit score. They don't anymore. They used to appear on the credit report as a judgment. They're not supposed to anymore. So since 2020, judgments are no longer supposed to be reporting. So if you do see one on a client's credit report, it's a matter of objecting to it through the credit reporting agency, and they should remove it. And as far as it being calculated in the score, it's not being calculated in the score, but that does not mean that a direct lender might not consider that there's an outstanding judgment when making a determination as to whether or not to extend credit, because that's a different consideration than the actual score. The score is just a number, and whether or not somebody is going to extend credit may or may not fully depend just on that number. I want to show you.
Oh wait, Bonnie, we got a question from Tanisha. Is there an income amount for head of household? I'm not sure what that went with. What
Okay. So the answer to that question is it depends on the state. So in Florida, where if you're head of household, if you're supporting an elderly parent, if you're supporting your spouse, or if you're supporting a minor child, as long as your tax return lists you as head, it has to be on the tax return. It has to list that you're filing as head of household. They cannot garnish your wages. I could get you out of that all day long. It's a matter of filing a notice of objecting to the garnishment or the bank attachment, and you can make it go away. There's forms. People could do it themselves. It's not really complicated. Okay, so this is an example of a consent judgment that was recently negotiated. It was an actual real person. They were being sued by Department Stores National Bank in Ohio. They owed $7,788.86. There were court costs of 123, so the total was $7,900. An agreement was made to settle it for 5480, so it wasn't a great settlement. And what I can tell you, and this is kind of a rule of thumb, once an account goes into legal status and they sue, most of the law offices are not interested in settling for less than 70 or 80% of the full balance. And that's if they will even settle for less than the full balance. Sometimes they'll only waive the costs and they will only take the full balance and they will only take it over short periods of time. However, it doesn't mean you don't try, because I was able to get one at 60% over a period of almost 5 years yesterday. So it does happen. It's just, you gotta push and you gotta ask and you gotta be able to, make your client human. So in this particular case, there was an agreement of the parties. The judgment is being entered because the creditor is not going to do a payment plan without a judgment. The plaintiff has it and it's for the full amount. However, as long as they pay the 5480.15 in payments of $162.10 on or before the 29th of each month until it's paid in full, then they'll be able to have it dismissed and it'll be filed as a satisfied judgment once the final payment is made under the plan. So there is in here, if you were to look at this, there's a clause in there that talks about that in the event of a default, that they have the absolute right to go ahead and pursue. Now, I usually in my judgments will fight with them, because what happens if the client mails the payment and the post office loses it? If there's not a provision in the STIP that says upon notice they have 5 days to cure, that client may not know that the creditor didn't receive the money. So if your clients are not making the payments by calling up and paying over the phone and getting a confirmation number when they call, I would absolutely make sure that there's something in these STIPs that gives them notice of the default and at least a couple of days to cure it. So let's say the post office loses it, they go in the bank, they see the check wasn't cash, they could put a stop payment and do a payment over the phone and cure the problem and not have it end up in default. Because if this person goes into default, they're already $2,500 behind the 8 ball in just the amount that they owe. And now their wages could be garnished up to 25%, depending upon what state they live in. And yes, I was able to talk for 2 hours. And for those of you who know me, know that I can do that pretty consistently. Do any of you have any questions or comments or things that I didn't cover that in the event I do this again, you'd like me to cover that you want to share? I saw.
Hey Ronnie, Tanisha says since she did a chat, when a judgment is obtained in another state and then transferred to Florida, does the 20-year statute apply?
Okay, so that's more complicated. So let's say the client lives in, and I'm just going to pick any state. They live in Ohio. The judgment is entered in Ohio. The person decides they're going to move to California. And now they're in California. So that judgment debtor needs to take that judgment, needs to go and file it in California. They need to follow California's laws with regard to how you file and give somebody a notice that a judgment is now being put on record in the state they followed you to. Then if they want to go ahead and execute on it, they have to actually open something up in the court to do it. So they have to now execute, they have to open it up as a matter to be executed on through the court system. Like they have to pay fees. There's like fees you have to pay. I did it once or twice. It's kind of a pain in the butt. Most creditors are not really running around trying to do that. And it's not automatically 20 years in Florida. It's 10 years and then you need to pay to renew it. And if you don't pay to renew it, it goes away. If you pay to renew it, then you can keep it on there for another 10 years. I hope you guys enjoyed it. And I hope this provided you some useful information.